Hi, my name is Samson Ellsburn. I'm an attorney with Wilkie Fleury in Sacramento, California. And this is our next video blog on labor and employment law news and updates. In this video blog, we're going to be talking about the prospective obligations to engage in interactive process with employees and the obligation to provide a reasonable accommodation to employees who have disabilities. We had a recent case that was very instructive for employers in this state. In that case, we had an employee who was absent for 10 days in the year. Now, this obviously violated the employer's workplace conduct policies because that's a lot of absences in a year, right? So the employee was sent by the employer into the disciplinary process. And while the employee was in the disciplinary process, the employee learns that he has a disability. And so he informs the employer, and this is the first time that the employer learns that the employee has a disability. The employer worked with the employee to prospectively accommodate the disability and the limitations caused by that disability. But the employer did not change or excuse any of the past absences that the employee had. So when the disciplinary process was finished from the past absences, the employee was actually terminated and sued for wrongful termination because of his disability, because the employer did not engage in an active process with respect to those past absences, and because of a failure to accommodate those past absences. The Court of Appeal didn't buy it and supported the employer and affirmed the employer's termination of the employee, and reiterated that both the interactive process in California and the duty to provide a reasonable accommodation for employees with disabilities is prospective. Employers do not have to give employees a second chance just because a disability may have contributed to prior past conduct. So employers, keep in mind, that both those obligations are prospective, but also keep in mind that this would have been a different case most likely if the employer had known about the disability at the time that the absences were occurring. So we hope that you have found this video informative, that you'll join us for other labor and employment law news and updates in the future. Thank you.